agency. At this hearing, they may confront and cross-examine agency witnesses and present evidence of their own. Respondents may be represented by legal counsels. The cases are heard by an agency employee, usually called an administrative law judge, ALJ.
Yeah.
Also, unlike criminal prosecutions, the burden of proof in administrative proceedings is normally the civil preponderance of the evidence standard. The agency, in effect, functions as a police officer, prosecutor, judge, and jury. Ladies and gentlemen, everything that they come at us with are corporate agencies. They're all agencies. I have lists and lists. They all have tax identification numbers. In order to avoid unnecessary recourse to the courts, certain agencies in all states have been authorized through the exercise of quasi-judicial power to settle disputes. Well, we have something that we haven't had for 81 years. Judge rules administrative court system illegal after 81 years. A federal judge's ruling against the Securities and Exchange Commission for using its own administrative law judges in an insider trading case is perhaps the beginning of the end of the alternative system of justice that took root in the New Deal. So what we have here is it's a winning case where they won in Georgia, and I have the case. And it's a way that we can use this case and this information to turn this whole system around. Here's another bombshell. Rod Class gets fourth administrative ruling. Government offices are vacant. All government officials are private contractors. Recently, I was in another court, and I looked on the wall in the courtroom there, and it's the Oregon Judicial Branch Mission Statement. It's a nonprofit mission statement. Anyone that knows a little about nonprofit corporations, here it is, Oregon State Statement of Values, the corporation mission statement. So the evidence is there many times regarding, and it's like the corporate names that was mentioned a little while ago. I have the document here for the Duns and Bradstreet corporate numbers, and I also have the ones for Oregon. About 3 pages for all the agencies of something that was never in the Constitution. It's called the fourth branch of government. Where's that at in the Constitution, the fourth branch of government? I didn't hear you.
The people are the fourth branch of government.
Yeah, that's about right. They turned us into economic slaves.
That's what Judge Scalia said.
So, what I'm getting at here in a nutshell is we have a 2015 court case from Georgia that if we hook onto that with all these administrative officers coming after us, including the FBI. FBI is an administrative agency also. State agencies, state cops, they're all administrative courts. They're not real. And, you know, we can go with Freedom of Information Acts, or if it's state, the Public Records Acts, and ask them if they're, and set them up, ask them different questions that might be regarding your action that you might get into in the future.
Milt, can you tell us the name of that court case in Georgia?
Yeah.
The viewers will want to hear it too.
let's see, it's,
Bank of US versus Blanter, Bank of Georgia.
it's the Charles L. Heel Jr. plaintiff versus the Securities and Exchange Commission as defendant. It's a civil action number 115 CV-1801 LMM. United States District Court for the Northern District of Georgia, Atlanta Division. And it's a very good United States District Court case. And was decided on June the 8th, 2015. And you know, that's only been a little over a year ago. Yes?
Can you repeat that case number, please?
Civil action number 115-CV-1801-LMM. United States District Court for the Northern District of Georgia, Atlanta Division. So it's got a case summary, and it's, you know, it's not that thick of a case, really. It can be used for everything that was discussed here, basically, that was negative. It can be used individually when any agency, administrative, judge, officer comes after you, making a claim against you, because they don't have the authority to do it. Where do they get their authority? They need you to agree to it, to consent to it. If you do non-consent, non-agreement, non-acceptance, you haven't agreed to the venue and jurisdiction. Theirs is not a, it's an unconstitutional jurisdiction that they're using because it's corporation and it's administrative law. And as I quoted in the law book a little bit ago, they're everything. They're the police, they're the jury, and whatever they want to say or do. It's right in their law books, and I got several of these books that say the same thing. That was all I wanted to mention for now. I think.
Thank you.